Good afternoon. Thank you for joining us for our panel discussion today. We are calling this presentation PERB Hearings, Do's and Don'ts. ALJs discuss best practices and answer questions from constituents. I am Valerie Pike-Bracho, Deputy Chief Administrative Law Judge at PERB. With me today are two senior ALJs, Jana Ellingson-Kegel and Bernard Rohrbacher. As Administrative Law Judges, we oversee the hearing process at PERB. The idea behind our discussion today was twofold. First, ALJs consult with each other frequently over issues that come up in our cases. It could be something novel or just something that we want to see what another ALJ would do in the same case. So we don't always do things the same way, and we have a lot to teach each other and to learn from each other. So we thought it would be a good idea to share this kind of an insider conversation in order to allow for practice tips to be shared with public. Secondly, we wanted the opportunity to answer questions directly from our constituents. Back in May, PERB circulated an email with a link that allowed people to submit questions directly to us. We received quite a few questions, and we decided to answer 3 of them during our discussion today. They can be loosely categorized as involving pre-hearing issues, the hearing itself, and post-hearing submissions. And our discussion today will be centered around those topics for PERB's process. Speaking of pre-hearing issues, if you missed the PERB webinar in April, that was by Chief ALJ Eric Koo and ALJ Quadros, I really suggest you take an opportunity to look at that at some point. It gives you an in-depth overview of how to prepare for a PERB hearing. Prior PERB webinars are available on PERB's website, and they cover all divisions of PERB and give you some really useful information. But before we begin our discussion, I need to let you know that the views expressed in this presentation are those of the presenters and are not PERB's official position on any matter. This content is for general informational purposes only. This information is not legal advice. Some statutes PERB administers have unique characteristics that may differ from the general principles discussed here. Please refer to the specific statutes, regulations, precedential decisions, or other legal authorities as appropriate. You can send questions about this material or PERB's processes to our email address, perbquestions@perb.ca.gov. With that, let's turn to our first question, which is, what considerations do you weigh in determining whether to hold an in-person or virtual hearing, especially where the parties do not agree on format? Judge Ellingson-Kegel, I'm going to ask you to start us off. And what do you think about hearing format disputes?
Well, I mean, I think that the place that I always start is with the parties' preferences. If the parties are in agreement about holding a virtual hearing, typically I'll hold a virtual hearing. If the parties are in agreement about holding an in-person hearing, typically I'll grant that request and hold an in-person hearing. You know, both of those with some exceptions. There could be good reasons why I would not grant even an agreed upon request for either a virtual or an in-person hearing, depending on a variety of things. But if there's a dispute, which is what the question's really about, I always want more information. Usually what I'll end up doing is scheduling an on-the-record pre-hearing conference where I can ask the parties about the reasons for their preferences, and then get a sense for sort of what are the issues driving a request for either a virtual or usually the dispute, a dispute about an in-person or virtual hearing. And then I think that the big things I'm looking at are if there are technological barriers to holding a virtual hearing, if there's some sort of necessary accommodation. And then the other thing is always sort of location and scheduling. PERB's constituents cover the entire state, and we only have offices in a limited number of locations. So typically sort of the ability to easily access a virtual hearing versus having to drive a long way for an in-person hearing could be a factor that I look at.
What do you think, Judge Rohrbacher?
Yeah, and picking up on the last thing that Judge Ellingson-Kegel said, if there is a long distance to drive for the parties, I'm also looking at, is there perhaps an aspect of one party wanting to make the other party drive the distance? That is not something we like to see. One thing that I frequently hear from parties who are requesting a in-person hearing, that it would help the determination of credibility. And there I have to say two things. First of all, very few cases, in my experiences, are decided based on adverse credibility findings regarding a witness. But if there is such a finding, the virtual format does allow us to assess credibility through demeanor by the witness just as much as an in-person hearing does, in my experience. Going just slightly off the topic, I want to say that focusing on the credibility of the witness often leads to a recurring problem, and that is over-reliance on cross-examination for the purpose of puncturing the credibility of the witness. If you do have evidence that will show that a witness isn't telling the truth or can otherwise not be relied upon, by all means. But oftentimes the parties don't have that evidence. So what they're trying to do is, through extensive cross-examination, trip the witness up. That almost never works. And just telling one little war story here, my very first arbitration, I had a witness, I was cross-examining a witness, and for some reason in this case, it mattered whether the supervisor signed a form that had supervisor under the signature line. And it looked like he had crossed out supervisor. And for some reason, I cannot recall now, this mattered. So I had him already testify that, yes, I crossed it out. And then I went on. And he got bored. And he looked at the document some more and he said, wait a second, that's just how I sign my name. I have this flourish where I underline my name. See over there in the other document, I do the same thing. All of a sudden, that witness was no longer helping me, and I was very concerned I had lost the case, which I hadn't. But my appeal to the parties, do not rely excessively on cross-examination. It is only an opportunity for that witness, for the other party, to repeat the same story again. And the more you hear a story, the more plausible it sounds.
I think, you know, when there's a dispute, most of the time they center on travel. And I will take that into account when I'm setting the hearing format. If the parties are coming from, you know, several hundred miles away, and if it's a lengthy hearing, now everybody's going to have to incur a lot of expense, stay overnight. So I will consider those types of issues when I'm deciding the format. One thing I have done too, in cases that have a lot of press interest, for example, I might want to have that in person, just so that I can know exactly, you know, who's in the room, what's being, you know, shared publicly. Sometimes, even though we will say, you know, you can't record, there's no unauthorized recordings of our proceedings, we give those types of admonitions. You don't always know what's happening because we're seeing everybody from, you know, sort of chest high. And so if everybody's in the room with me, I know what's going on, and I have sometimes a little bit better control over what's happening. So that might be something I take into account. But I think, you know, the video hearing format has really opened up the process for our constituents in a way that has been, you know, really good, allowing people, you know, broader access. And sometimes I can see the witness even better on the screen that's right in front of me than, you know, having to look to my side when I'm in person. So I really don't think the credibility suffers through the video format, because I know that sometimes people have that concern, or that's what we hear a lot of times. Before we move on to the second question, are there any other like pre-hearing issues that we would like to discuss and share best practices for?
Well, I think I have like two big, I have a long list of big pre-hearing do's and a couple of pre-hearing don'ts. One thing that frequently becomes a area of dispute for the parties is discovery, subpoenas, and I think a well-crafted and specific subpoena, like record subpoena, is a great tool. And I think a thoroughly responded to subpoena and a good use of the meet and confer process for those discovery disputes is a really good use of the parties' time. There are certainly circumstances where I expect and am happy to decide a motion to compel or a motion to quash, but the parties are sort of in a superior position to know what documents they're looking for, what documents they have, what the privacy concerns are. And so I think that, do use those processes and then talk to the other party. And that goes not just for discovery disputes, but for scheduling issues, for evidentiary disputes, anything that is going to come up and needs to get hashed through. I really appreciate the parties' efforts to talk about those together before they come to me as the ALJ, which leads into one of my big pre-hearing don'ts, which is please, from my preference, I do not wish to be carbon copied on preliminary disputes between the parties, because I don't think it's helpful. And it also gives me a sense that you're not really interested in resolving this preliminary dispute. You're trying to use it as a way to sort of get a leg up on the other side. The reality is those disputes aren't before me until they are made on the record or filed in EPERB. And you will have every opportunity to include your correspondence when you make that filing or submit that motion. So I don't appreciate sort of the courtesy copy of the parties' disputes, because it doesn't send me a very good message that the parties are making an honest effort to resolve those disputes before bringing them to me.
But talk to each other as much as possible before, during, and after the hearing. Discovery disputes, I think it is no secret, are disliked by judges. Too often the requesting party asks for too much, and too often the responding party is willing to provide too little. And it becomes a way for jousting for position. If you leave it to us to decide your discovery dispute, probably neither party will like the result. Also, we want you to talk to each other because we believe that this increases the chances of settlement. The more the parties talk to each other, the more they are likely to settle a matter. And although it will put us out of business, I do believe that in almost every case, a settlement is in the best interest of the party. Very brief other war story from the very last case, or one of the last cases I did, where I stood and on principle and didn't settle a case because I wanted this matter cleared once and forever. And what happened? And the other side was willing to give me what I could get from the arbitrator, but I wanted a decision from the arbitrator. We lost the case. So don't let that happen to you. Don't have an unrealistic evaluation of your chances of winning. Many decisions, just like many resolutions of a discovery dispute from a judge, will not make either party happy, and you will be better off if you settle that case and improve your relationship with each other in the process.
So, regarding discovery disputes, I almost never resolve them without convening a pre-hearing conference where the first thing I'm going to do is order them to meet and confer. So I sort of will make a supervised meet and confer process if they haven't been doing it on their own. Like you said, it's no secret that nobody wants to resolve these things. So they're just going to be ordered by me to try one more time if they haven't been making a good effort to try and get it resolved. The one thing that I will say about sort of a don't tip, pro tip for our constituents is review PERB regulations too. Especially the section on hearings. This is especially true of counsel that's appearing before us. Oftentimes I get some odd questions from counsel that could have been easily resolved by just looking at our regulations. So I really encourage our practitioners to review them carefully before asking our staff or submitting questions to the judge. So that's sort of my big takeaway on the pre-hearing process. If there's not anything else, we'll move on to the second question. Okay, so second question is, what is tripping up parties from being able to state a prima facie case? And I can start us off here, where I think, especially for unrepresented folks, once they get a complaint, they may not have a full understanding of what comes next, and they may be like really excited, thinking that, okay, this is kind of a done deal at this point. And, you know, the reality is, you know, that everything in the complaint has to be proven at the hearing. They need to be able to call witnesses and present evidence, documentary evidence, or you know, whatever they can do to prove that case. And I think that sometimes there's a disconnect for unrepresented litigants that they don't fully understand what it means to have to prove all those allegations in the complaint. So I'm just going to use as an example, like a really common complaint pattern that we would see in a retaliation case, like under the Educational Employment Relations Act as an example, a complaint that says something like, on May 1, charging party, you know, exercised rights protected by ERA by filing a grievance under the collective bargaining agreement between the union and the respondent. On June 15th, respondent, acting through the principal, took adverse action against charging party by issuing a letter of instruction. And then, you know, the next step in the complaint is, you know, because of the activities described in paragraph 3 on the respondent, you know, retaliated or violated ERA through their actions in paragraph 4. And I think sometimes, you know, this might seem really straightforward to the charging party, but, you know, they have to put on evidence of the protected activity. For one, you have to be able to show that you did all those things, but something they might overlook is they have to show that the person who took the action against them, the principal in this case, was actually aware of that grievance, which sometimes might be easy to show, but other times they may not realize that, oh, this is something that I need to put on in my own case before the respondent gets a chance to put on his own evidence. And not understanding sometimes too that, you know, the important piece that's not described in the complaint is the, you know, the because of the protected activity, the nexus element, and not understanding what kind of evidence they may need to show by calling witnesses, by showing documents that could prove disparate treatment, or that there was an exaggeration or something in the rationale that was provided to them. These things may not be readily apparent, and I think so sometimes it's just not knowing exactly what they need to do to prove up their case, and then sometimes it's just that the facts that they do put in the record are not enough to defeat the other side once they get to present their evidence and show you know, a non-discriminatory reason for the action they took. Sometimes it's just a failure of proof, but just for them knowing going in exactly what they need to prove is probably really key.
Yeah, I would say the same thing, and it goes equally for charging parties trying to make a prima facie case and respondents trying to prove their affirmative defense is sort of jumping off what you said, knowing what the elements of the allegation or the defense are, and then, you know, soliciting the right evidence to get there, asking the right questions, subpoenaing and moving into evidence the correct documents. But that all starts with sort of the foundation, like, hey, have you done your pre-hearing work to do the right research so that you are familiar with what those elements are? And the elements are not always spelled out in the complaint. The elements of the defense certainly are not spelled out in the complaint. And making those, doing that preparation to ask the right questions and put forward the right evidence, so that when you get to the last part that we'll talk about, your sort of post-hearing arguments or your post-hearing briefing, you have all the right pieces to make those arguments.
Yeah, and I think preparation is the key. In order to know the elements of your case and to address other legal issues in the case and prepare yourself for them, the PERB website has a really helpful tool. If you go on the PERB website, on top there is a ribbon, and one of the options on the ribbon is decisions. If you click on that, you will have further options. You can find there all the presidential PERB decisions that have been issued, but perhaps more importantly, when you have a complaint issued and you have to figure out, well, what do I have to prove? There's a topic index that will have separate entries for every type of claim and every type of defense, and also procedural actions. So use that topic index to prepare yourself for the case. Then, something very simple, talk to your witnesses before the hearing. I once had a case where I asked counsel to call the next witness, and this was an in-person hearing. Counsel left the room, didn't come back for 5 minutes. I got antsy and wandered through the hallways to find that counsel in a breakout room preparing their next witness. This is so wrong for so many reasons, but most importantly, you haven't prepared your witness. How can you expect that witness to give you the answer that you want him to give? Also, when you're questioning your witnesses, your own witnesses, you should not ask leading questions. But my purpose of talking about this is not about this fact. Let's say nobody objects to leading questions. The truth of the matter is that if I have a witness being asked the questions, what happened at that conversation? And the witness says, well, my supervisor came to me and yelled at me. And take this versus the question, isn't it true that the supervisor yelled at you? Yes. Between those two witnesses, I weigh the first witnesses much more heavily than the second, even if no objection has been raised. The final detail I want to talk about is hearsay evidence. This is perhaps the most important evidentiary issue because, unlike in a courtroom, hearsay evidence is admissible. But our regulations specify that hearsay evidence by itself is insufficient to support a finding of fact, meaning it can only be corroborating evidence. You need to have a non-hearsay witness testify about a matter. Only then can you use the hearsay witness to corroborate that testimony.
Judge Rohrabacher, what's hearsay?
Hearsay, well, this is actually a difficult question, right? Hearsay is testimony or a statement by an out-of-court statement that is introduced to prove the matter asserted therein. What does that mean? Supervisor says, I'm going to fire you. Okay, and you state and you testify, the witness testifies, the supervisor said that he would fire me. Now, if that is introduced to prove simply that the supervisor said it, it's not hearsay. But if it is introduced to prove that he would fire him, it is hearsay, right? There are tons of exceptions, okay? Again, the index on our website will help you with that. But if you have a statement that was made out of court and you want to use it as evidence that what's said in that statement is true, right? That's maybe an easier way to say it. Then it can only be corroborating evidence. It cannot by itself be used to prove the matter asserted.
So you branched out a bit from our question, but I just want to make sure we cover all the hearing topics that we wanted to talk about before we move on. Anything else on the hearing itself?
I mean, I think in terms of do's for actual hearing practice, things that are helpful to me. I would advise parties to pick your battles at hearing. Parties have the right to raise objections to testimony and evidence, but your fights about evidence or testimony at hearing, give me information about what you think is important and what is important to the case. And so it's wise to, to focus your fights on where the real issues are, because I'm going to take information from that during a hearing itself. The other thing, like with pre-hearing, my expectation is that parties will talk to each other about what the hearing process is going to look like, about their scheduling issues, about whether there are witnesses that need to be heard out of order in order to efficiently sort of fit everything in. I really appreciate the efforts the parties can make to do that. And in general, if the parties can agree to take a witness out of order, to work their scheduling so that we can make the best use of our time, I'm going to honor those agreements. We're not going to have a lot of discussion about them. If you can take the time to have that discussion before we get to a hearing. One of the preliminary questions I always ask before a hearing day starts is like, are there any scheduling issues that we need to talk about this morning? Anything I need to know about? And I love it when one party says, opposing counsel and I have already talked about it. We have this one witness who we're having a hard time getting. They need to testify at 2 this afternoon. So no matter what happens, we're going to break and bring them on at 2. And that just really helps us use our time efficiently and make sure we can fit everything we need to in. The exception, I think, in my hearings, to my ability to grant any agreements the parties have made about scheduling are any scheduling that is going to limit the amount of hearing time we use in a particular day and influence whether we're going to be able to finish a hearing on time. So while I appreciate the parties' ability to say, hey, I've got a conflict at 2:30 this afternoon, we need to break our hearing day today at 2, it doesn't really matter to me if the opposing party is willing to agree to that. It is a concern for me if we're having sort of a last minute scheduling change where we're not going to use a full day of hearing, because I want to use all of our available time.
Yeah. You don't want me to say, why am I just hearing about this now? Like, that is a phrase that you wouldn't want to elicit during the hearing. Like, if we talk about it pre-hearing and say, oh, on this day, we're not going to have anybody be available after 3 p.m. We're going to have to, it would be best if we could break early that day. As long as I know going into it, and we can accommodate by scheduling, starting early, figuring out maybe we can go a little longer on another day. But, surprises during the hearing itself, that's not welcome.
Yeah. And picking up of what Judge Ellison Cagle said, don't use the process to annoy the other party. For example, objections. Raise objections when you need to raise them, not to throw the other person off, not to, interrupt the flow of testimony by opposing counsel. We notice that, and we don't like it. Agree to documents that are true and authentic documents, right? We understand it is an adversarial process, but nevertheless, there are ways to fight fairly, and there were ways to fight dirty. And to emphasize what both Judge Racho and Judge Ellison Cagle said, when you come to us and say, oh, we've agreed to continue the hearing. That's very nice that you agree to continue the hearing, but I may not. And it's not us somehow, asserting our authority for nothing. Remember, we gave you those hearing days as opposed to another set of parties who have another case. Their case is now being heard later. If we reschedule your case, those dates are now unavailable for other parties. So the reason why an agreement by the parties on scheduling issues may not lead to that agreement being honored is that it impacts other parties in their cases, and that we cannot allow other than for good cause.
Well, yeah, and as Judge Racho mentioned earlier, the regulations, our regulations spell out really specifically what's required to get a hearing continued, including that it's different, shortly before the hearing and further out before the hearing. And so looking at the regulations, knowing what you need to do in order to make your case for continuing a hearing is gonna help you. Something that you said, Judge Rohrabacher, reminded me of something I forgot to say in our pre-hearing section, but I think it applies to during the hearing process as well, is that I always appreciate the parties' efforts to stipulate to documents in advance of the hearing that they know that they're both going to use. Sometimes it doesn't happen. I understand that there's a lot to do to prepare for a hearing, and you don't always have as much time as you would like to confer with counsel about which documents you're both planning to introduce. The other thing that I think is always really helpful are factual stipulations. Any case that comes before me, there is a dispute, but that dispute is not always about the facts. And it's usually not about all of the facts, even if it is about the facts. At any time that the parties can spend prior to a hearing figuring out what they agree on, putting that down in writing, and then submitting it to me is time we don't need to use at the hearing to go over things that the parties don't dispute. And that can really help you, again, use your time efficiently, make sure you can get your hearing done in the amount of days that we've scheduled, and make sure that your ALJ's focus is on the things you actually have a dispute about and not the things that you agree on.
Yeah, good points. Don't be afraid. Don't be afraid to enter into stipulations and joint exhibits. Always welcome. All right, I think we can move on to our next question, and the final question. And that is, what are some recurring mistakes that we see in submissions? Judge Rohrabacher, I'm going to ask you to start us off on this one.
Couple things. Be sure that your post-hearing brief addresses all claims and all elements of the claim. I'm right now working on a decision where one of the parties simply ignored one of the claims in the complaint. Now, they're still winning on this issue, but in another case, that may not be the case. A very easy way to write an effective brief that addresses all issues is to use the headings to separate each claim and each element of the claim or of the defense. And trick is to afterwards take all these headings and work them into a table of contents. That serves two purposes. The lesser one is that it makes us happy because we're helped by having a table of contents. But the other one is when you have the table of content and you read down that table of content, it should essentially give you the structure or reflect the structure of your case. And you can then notice, oh, I don't have a heading for this element of this claim or for that entire claim. I need to add that, right? So that is one thing. The next thing is very important. Support your statement of facts with citations to the record. I always instruct my parties at the end of the hearing that every statement of fact, every sentence that's a statement of fact in the statement of fact section should be supported by a reference to the record, either the transcript volume, page, and line, or a document, an exhibit with Bates stamp number. If there is a sentence that is a statement of fact and that's unsupported, you take the risk that I may not recall the facts being that way, and then I will not find that fact. In the argument section, I really only want to see references when they're or citations to precedential board decisions. So, or including precedential board decision that adopt, and that is a magic word. The decision has to say adopt a administrative law judge proposed decision, okay? If you cite to a non-presidential board decision or to a ALJ proposed decision that was not adopted by the board, we notice this, and again, the lesser reason not to do it is that there's some annoyance factor on our part when this happens, but the more important one is there may be a perfectly good presidential board decision that on that topic, and you forgo the opportunity to cite to that board decision. Next, when you're done writing your entire brief, please spell check it and proofread it, okay? I get too many briefs, and I'm sure I'm not the only one, with glaring typographical errors or sentences that through cut and paste have been rendered unintelligible. Now, I do have to say, address one issue, and that is using AI to research and or write your brief. To be sure, it is perfectly legal to do so, but you must check the source for everything AI tells you. Every quote, every page number, every summary to a case must be checked. There is a board decision from last December that makes it very clear that if your brief contains hallucinations, meaning cites to non-existing authorities, or when it cites to authorities, cites to quotes that don't exist in that authority, or to pages that don't exist in that authority, we will notice, because we do read briefs and we do look up the cases. And the board has made clear that under these circumstances, a variety of sanctions, from monetary sanctions to striking that brief, which means not considering that brief, can be levied on that party. And I unfortunately had to do so in a case myself at the end of last year. You do not want to be in that position. So if you use AI, please check the sources to make sure that AI is telling you the truth and is not making up things to please you. But I'll end with this. Sometimes I think parties believe that judges make up their minds by the end of the hearing, or maybe even before that. That is not true. We make up our minds based on the record and the briefs that interpret that record. We read the briefs. I'm sure that we all read them more than once. We read them before we start writing the decision, and we read them again at various points while we're writing the decisions, and we change our minds. I just now have another case with a non-lawyer represented party, and that party wrote a great brief, and it changed my mind on that case. So don't think this is either a waste of money or of time. It is not. A well-written brief can make all the difference. I'm going to end it on this, actually, and that is, tell us the story. Tell us the story as early as possible. What that means is, when you file your charge, tell us the story, and if there are documents that support your story, attach them to your charge already then. For respondents, tell us your story as early as possible. Some respondents forego the opportunity of filing a position statement. That means I'm only aware of the charging party's side of the story. You don't want that. Your position statement should substantively address the charge rather than arguing that it is not, the facts aren't specified and specific enough to support a complaint. That argument, I'm not sure, I never say never. Maybe it has worked once, but I've never seen it work. So respondents, please file a position statement. By the same token, in my view, at hearing, my personal opinion is, and there are some exceptions to this, and I respect if there's even different opinions on this, but each party should give an opening statement unless they have a very good reason not to do so. Because if I only hear from, let's say, charging party, and respondent reserves their opening argument, that means that through the entire case in chief of charging party, I only have in the back of my mind their story that they gave me during their opening argument, right? I really want to have respondent side of the story from the beginning so that I can weigh the evidence that charging party puts on, not only in light of the story that they are telling me, but also in light of the story that respondent is telling me.
I will say the flip side to the argument about reserving the opening statement, if they think that, if the respondent thinks that charging party's case is extraordinarily weak, it might be a good opportunity, if they haven't made a motion to dismiss previously, it might be a good opportunity to just highlight in their statement where the shortcomings are in the evidence. That could be a possible reason to reserve it, but most of the time I agree with you. I think I'd like to hear both back to back so I can kind of have a map of where we're going to go and what the story's going to, how it's going to unfold.
I tend to agree, including that if it really ends up being the case that a charging party does not present sufficient evidence, having the respondent having made their opening statement is not going to waive their right to file a motion to dismiss at the close of the charging party's case in chief.
Right.
All you will have done is given your ALJ a frame for the evidence that they're starting to hear. And I always find it helpful, particularly in cases where there is not a thorough position statement or the position statement only covers some things. And I recognize that position statement serves a purpose at the sort of initial pleading stage in the office of the general counsel, but it's an important reminder that ALJs use those documents as well. Those are sometimes the first things we have access to when we open up and review a case file is the charge and the position statement. And those often have a bunch of information that the complaint and the answer don't have in them. And so they're important ways that we start to understand what a case is actually going to be about.
I agree.
I forgot one thing, and that is when you write your brief, focus on the arguments that you think are really winners. Too often parties throw in the kitchen sink and raise arguments that stand no chance in hell. And that kind of dilutes your argument. It makes your good arguments look weaker than they are. So make arguments that you believe in. And that you can prove, rather than arguments that are theoretically available, but here will not carry the day.
Any other post-hearing topics that we haven't covered? I will say, just on the subject of briefs, very quickly, keep them brief. Unless it's a 14-day hearing with 10 issues, please, under 50 would be good.
Yeah.
Yeah, I tend to agree that there isn't a page limit on briefs to administrative law judges, but I want the most relevant information in the brief. I want your best arguments. I, like Judge Rohrbacher, want citations to the record. One mistake I see a lot, because it's not required by the regulations, it's not, but parties spend resources to obtain transcripts and then they don't cite to the transcripts in their post-hearing briefs. And if you are quoting from the transcript, I want to know where that quote is. And even if you're just explaining something that you think came from the testimony, I want to know where I can look to find it. It's going to help me. It's going to help me write a proposed decision. It's going to help me get you a decision more quickly. And it's just good use of something the parties have used their resources to obtain in not all cases, but in a lot of cases that come to us. The other thing, and it dovetails a little bit on the issue of AI, but it's not unique to parties who have used AI in their submissions, is citations out of context. So citing what is an actual quote from a decision that does not actually sort of help your case. And sometimes I've had it be the case that it's like a quote from a proposed decision, but the quote is to a from a board decision that's a quote from a proposed decision that was not adopted on an issue that was actually overruled, or I've had parties submit sort of arguments with citations to a board decision that was explaining a party's argument that they did not credit. And so, I mean, I think just be careful when you're using those citations in the brief that you're actually citing to the holdings of the case and not just sort of random things that exist in the decision but are not actually the findings of the decision, because that is going to be a real quick way to let me know that you didn't do very careful work, and I'm not going to credit that argument because it's not actually supported by the precedent.
Don't mischaracterize either the hearing record or the case law, because I think it when that happens, it really makes you question, you know, like you had mentioned earlier, I think when we were talking initially about this topic, it makes you question the rest of their good arguments. So be very careful when quoting anything from the testimonial record, from the documents, or from case law itself.
And I'm harping on this, I know, but it's never too late to settle a case. Even after the evidentiary record has been established, even when you're writing a brief, now you know what the evidence is. Now will be the point in time where the case can settle. So we are never upset, even if you've submitted your briefs. And I've already spent a month on the decision, and you let me know that, oh, we've settled this, here's the withdrawal. I'm going to say, good for you, congratulations. And the next time you're around before me, I will be more favorably disposed to you, because I know these parties can settle, okay? And again, the longer I've done this on your side of the bench, the more I became convinced that settlement, as I put it, if I could get my client to sign on the line, muttering epithets under their breath, some of which directed at me, I knew that I had done the best job I could do for them.
Yeah, I think that's an important reminder that, like, it's the settle. You know, you have an opportunity to settle before a case ever gets to an administrative law judge. But you know, you could come to me in the middle of a hearing and say, the parties, you know, we broke for lunch and the parties have reached a settlement agreement. And
this is great news.
Yeah, it's great. It's great news for everybody. I do think that the parties often are in the best position to craft a resolution that's going to work for everybody. And what you get from an ALJ, despite our best efforts, is not always it's usually not what either party wants, with rare exceptions.
All right, so let's move on and have some final thoughts. Could be on any portion of the hearing process. Anything we want to wrap up on? I will say, to bring it back to AI for just a moment, not in brief writing, but in pre-hearing motion practice. I don't know about you two, but I have been seeing some strange motions come my way, and I think that Claude or ChatGPT has a hand in some of those motions, and I would just caution people, again, look at the regulations, and you know, there's certain things that are legitimate to bring, disputes over enforcement of a subpoena, a motion to amend the complaint, a motion for summary judgment, things like that, but just very odd stylings in the filings I have been seeing, and just because you can file something doesn't mean that you should. So that's what I would end with on a practice tip.
My practice tip is treat each other with respect. Again, this is an adversarial hearing, I get it, but even if you're adversaries, each side consists of human beings, even if they represent an entity. Every human being is entitled to their dignity and respect, and that doesn't go away in the hearing room. So please, and I know how easy it is to forget that and to err in this matter. I did so when I was in private practice, no question, but these are my least favorite memories about the time in private practice when I treated another side not with the respect and affording them the dignity that they're entitled to. So don't make that mistake. Treat each other with respect. We are interested beyond the narrow issues that are before us about the relationship between the parties. And we're interested in moving that in a favorable, positive direction. And one side winning isn't always the best way or rarely actually is, the way that this relationship can be put on a positive path. So keep that in mind as well. When you file your charges, when you raise your defenses, is this moving these two parties in a positive direction, or will it make matters worse?
Mm-hmm. I think that's a really good reminder that, not all of the cases that come before PERB ALJs, but a good chunk of them are between parties who have ongoing relationships and who will continue to have an ongoing relationship. And, part of PERB's mission is that sort of harmonious labor relations. And despite the fact that the hearing process is adversarial, like we are a part of fostering harmonious labor relations. And so anything that the parties can do, any places that you do agree, know where you agree, share that with the ALJ, and show us that you're being thoughtful about when you come to a hearing, thoughtful in sort of all aspects of it. The other sort of final thought that I will give that I think I sort of maybe missed in my earlier discussion is one thing I really like to use to make the hearing process run smoothly is this sort of pre-hearing conference process. All the ALJs do things a little bit differently. I like to sort of schedule, as a matter of course, a pre-hearing conference about a month out from hearing where the parties have an opportunity to raise issues. And I also always appreciate if a party reaches out to me and says, hey, we have this evidentiary issue. We know it's going to come up. We know it's going to be a dispute. Can we schedule a pre-hearing conference to talk about it in advance? And that essentially just gives us a jump start gives me a jump start on hearing issues, gives the parties a jump start on hearing issues. And then I think it also is an opportunity if there are questions about the way a particular ALJ may do something that's not covered by the regulations, which you have already reviewed because you listened to Judge Racho. You can always ask. I'm always open to sort of questions about what parties can expect in a hearing from me, how I deal with things, so that nobody's surprised when they show up for a hearing about how things are going to run and how sort of the general procedure is going to go, even though there always are surprises with testimony and evidence, et cetera.
One very last thing I will say is don't be afraid to ask for help if you need someone from PERB to assist in settlement discussions. It's never too late for that. During the hearing, that's okay. Just ask us. We can oftentimes facilitate that. We won't do the mediation ourselves, but we can often find someone to step in and assist the parties with settlement discussions. And, that's what we're here for. We're here to improve labor relations, and I think we all really take that to heart, and I would encourage the parties to seek help if they need it. I think that's probably a good high point to end on, and that's all the time we have today, but I want to thank Judge Rohrabacher and Judge Ellingson-Cagle for the very interesting discussion, and we thank everyone who's joined us online. We hope it's been useful to see how ALJs think. Please join PERB for our next webinar on August 13th, where panelists from SMCS and Office of the General Counsel will be presenting an overview of PERB representation matters, from petition filing to conducting elections. Thank you for joining us, and have a good day.